Good morning. This is your Keso Report from Monday, October 10th, and I'm your host, Clark Kelso. Well, we have just one liner today. In re Jose Rodriguez, the 4th District rejected an inmate's appeal from the denial of his request for parole. The defendant had been convicted of second-degree murder in 1987. The inmate had behaved well in prison, but never offered an explanation for the murder he committed in 1987. Instead, on advice of counsel, he has remained silent about what led him to commit the crime. Absent that explanation, the parole board held they had no basis for determining whether he had dealt with whatever were the issues that led him to commit his crime, and therefore he was still a possible danger to public safety. The 4th District affirmed. Also, applying a 2008 amendment to Section 3041.5 of the Penal Code, the board postponed his next parole hearing for 3 years. And the 4th District rejected the inmate's claim that the application of this statute violated the ex post facto clause, since the amendment does not increase the length of sentence and merely changes the administrative method by which a parole release date is set. Well, now we have a new feature. Every Monday we'll be adding to the Keso Report the grants of review from the California Supreme Court, so that we can keep up to date on what to expect from the Supreme Court in their upcoming dockets. First, we have an insurance case in Hughes versus Progressive Insurance Direct Insurance Company. The 2nd District had held that an insured could sue an insurer for an alleged violation of Section 758.5 of the Insurance Code, which prohibits certain practices involving recommending or requiring use of specific automobile repair dealers. Technically, Section 758.5 is not part of the Unfair Insurance Practices Act that was subject to the Supreme Court's holding in Maradi Shalal that the Act does not create any private causes of action. So, the 2nd District, citing that technicality, let the suit go forward. Now, in my report on this case back in June, I noted that, quote, the result reached in this case will catch the attention of the California Supreme Court, particularly since it is already another appeal before it involving the scope of Maradi Shalal, close quote. Well, that prediction came true last week when the court issued a grant and hold on the Hughes case. Next, in the area of criminal law and victim restitution. In People versus Verney, the 3rd District faced a question involving the scope of victim restitution in a criminal case where the defendant had poured gasoline on one Michelle B. in an apartment bedroom and lit her on fire. The fire spread to the apartment, causing substantial damage to the apartment building. The defendant pled guilty only to aggravated mayhem, that is, intentionally causing disability or disfigurement to another human being, in exchange for dismissal of an arson charge. The defendant claimed that because the arson charge was dismissed, the restitution order in the case should have been limited to damages to Michelle B. The 3rd District disagreed, holding that given the facts, the defendant set both Michelle B. and the apartment on fire in a single course of criminal conduct. Well, the Supreme Court has also issued a grant and hold in this case, and we'll see just how broadly victim restitution is going to be interpreted by the court. Next, in another parole case involving also sexually violent predators. In People versus Gilbert last June, the 2nd District ruled that the California Department of Corrections and Rehabilitation could lawfully hold an inmate scheduled for release for a brief period of time after that release date in order to conduct an emergency assessment of whether the inmate should be civilly committed as a sexually violent predator. Such assessments are usually performed well in advance of a release date, but this case managed to slip through the cracks, through no fault or negligence of anyone in the department. And because it slipped through the cracks without fault, the appellate court held, well, we can go ahead and have a temporary stay of your release. The Supreme Court has issued a grant and hold in this case. We'll find out if you can hold on to somebody past a release date in order to conduct a civil commitment assessment. Finally, in the area of labor law, in Santos versus Vitas Healthcare Corporation, the 2nd District affirmed denial of a class action to recover damages for an employer's alleged denial of meal periods where the issue was whether it was sufficient under the Labor Code for the employer simply to offer meal periods, as opposed to making sure that the meal periods were actually taken. And the claim by the plaintiffs here was that, well, they may have offered them, but because of the type of work they were forced to do, they really weren't able to get their meal periods. Well, this issue about meal periods is actually up before the Supreme Court in a number of other cases. And the court then issued a grant and hold in Santos as well. Eventually, we'll find out whether it's enough to simply offer to have a meal period during the day, or whether an employer really has to make sure that that time is set aside for meals. Well, and that's it for today's Keso Report. Have a great day in the law.